Before we begin, a quick and important disclaimer. The intersection of Islamic jurisprudence and United States civil family law is highly complex, constantly evolving, and deeply nuanced. The content provided in this video is strictly for educational and entertainment purposes only and absolutely does not constitute professional, legal, financial, or religious advice. I am not a licensed attorney, a judge, a financial advisor, or an Islamic scholar. The case studies, historical trends, and potential outcomes discussed here are meant to illustrate broader concepts and should never be used as a substitute for professional counsel. Family law varies drastically from state to state, and religious interpretations can vary significantly depending on the specific school of Islamic thought. Any decisions regarding civil divorce, religious annulment, asset division, child custody, or contract enforcement must be made after consulting with qualified, licensed legal professionals in your specific jurisdiction, as well as recognized religious authorities. Always conduct your own exhaustive due diligence before signing any legal or religious documents. Your personal circumstances are highly unique, and relying solely on internet content for legal or religious guidance carries substantial risks. Imagine stepping out of a state courthouse in New York, Texas, or California. You have the judge's signature on a final decree of dissolution. Your marital assets have been divided through the state's formula for equitable distribution or community property. Spousal support has been strictly calculated, and child custody schedules have been rigidly set into law. In the eyes of the United States government, your marriage is officially over. You are a single individual legally free to move forward. But there is a hidden parallel reality that the secular American judge did not and legally could not address. In the eyes of your faith, your community, and perhaps your overseas family, you are still entirely and unequivocally bound to your spouse. You are trapped in what scholars and legal experts formally refer to as a limping marriage. You hold a civil divorce decree that grants you secular freedom and independence, but you completely lack the religious divorce that grants you spiritual closure and communal recognition. Consider the catastrophic social, emotional, and psychological weight of this exact scenario. For a woman caught in this jurisdictional limbo without a religiously recognized divorce, she cannot remarry within her faith. If she attempts to move forward and build a new life, she faces intense social ostracization, and her future relationships are deemed entirely invalid by her community. For a man, the strict financial obligations dictated by complex religious contracts might still be hanging over his head, actively accumulating and remaining entirely unresolved by the civil court's final decree. This is not some rare, isolated incident. Historical trends, legal databases, and community data suggest that hundreds and potentially thousands of Muslim Americans find themselves caught in this excruciating jurisdictional nightmare every single year. They are crushed between the unyielding procedural machinery of the United States civil court system and the deeply rooted abstract concepts of Islamic family law. The stakes in these situations are astronomically high. When these dual-system marriages dissolve, individuals frequently rely on a specific document signed on the day of their wedding, the mahr, or the Islamic dower. Many individuals falsely assume this religious document will protect them financially in a secular American court. But what actually happens when you bring an Arabic-language religious document into a secular, state-run courtroom in Michigan or Florida? The First Amendment of the United States Constitution, specifically the Establishment Clause, explicitly forbids the government from entangling itself in religious doctrine or interpreting religious texts. This means an American family court judge cannot legally rule on whether you have been a compliant spouse according to religious standards, or whether a specific theological condition has been met. Consequently, we see shocking case studies where civil courts completely invalidate the mahr, treating it as a fundamentally flawed prenuptial agreement simply because both parties did not have separate, secular legal counsel when they signed it at the mosque. In these devastating moments, individuals who believed they had a solid financial safety net are left with absolutely nothing, stripped of their expected assets. Conversely, in different jurisdictions, other judges might choose to enforce the mahr as a strict, standalone secular contract, intentionally ignoring the complex religious context entirely. This approach frequently forces massive, unexpected financial payouts that completely bankrupt the other spouse, violently disrupting the state's standard equitable distribution laws and leaving both parties in a state of financial ruin. So, how do United States courts actually navigate this constitutional and legal minefield? Can a religious divorce mandate ever be enforced by a secular judge without violating the separation of church and state? And what is the single most destructive, incredibly common mistake that couples make when drafting their Islamic marriage contracts in the United States, a mistake that practically ensures a chaotic, heavily litigated, and financially devastating legal battle if the marriage eventually ends. The answers to these questions lie hidden within a complex web of obscure legal precedents, appellate court decisions, and deeply misunderstood religious tenets, and we are going to expose exactly how this hidden system works. This deep dive masterclass is meticulously designed to solve one of the most complex, intimidating, and fundamentally misunderstood problems facing Muslim Americans today: the terrifying ambiguity of navigating a dual-system divorce framework. If you are living in the United States adhering to Islamic principles and facing the daunting prospect of marriage dissolution, you are actively operating in two entirely different, often opposing worlds simultaneously. The core objective of this breakdown is to completely demystify this turbulent process for the U.S. audience. We are going straight into the abstract concepts of divorce in Islam, such as talaq, the unilateral repudiation traditionally initiated by the husband, khula, the separation initiated by the wife, and fash, the formal judicial annulment, and we are going to seamlessly map them directly onto the rigid United States civil legal framework. We will not waste your time with vague philosophical overviews or purely theological debates. Instead, we are going to look strictly at actual potential outcomes and deeply analyze historical trends from state supreme courts to see exactly how these two powerful systems collide, interact, and frequently contradict one another. You will learn precisely why attempting to translate Islamic legal terms directly into American legal concepts, such as confusing a religious dissolution with a secular no-fault divorce, is a massive strategic mistake that can permanently cost you your financial security and parental rights. You will fundamentally understand the critical structural difference between a religious tribunal, such as a localized Sharia board, and a state-sanctioned family court, and why a binding ruling from one does not automatically carry any legal weight or enforcement power in the other. Furthermore, we are going to break down the exhaustive, step-by-step reality of what happens when faith-based contractual obligations violently clash with secular civil rights in an open courtroom. We will explore exactly how different legal jurisdictions handle these volatile cases. For instance, you will see how a community property state like California treats the valuation of an Islamic dower, compared to how an equitable distribution state like New York or New Jersey manages that exact same asset. We will examine the specific legal strategies, arguments, and precedents that specialized family law attorneys use to either aggressively enforce or systematically dismantle religious contracts within a strictly secular setting. By the end of this intensive masterclass, you will have developed a comprehensive, high-level understanding of this fractured legal and religious landscape. You will be fully equipped with the knowledge required to recognize the inherent structural flaws in how religious marriage contracts are typically handled, drafted, and executed in the United States. You will see exactly how to safeguard your civil rights while simultaneously attempting to honor your personal religious convictions without compromising your future. Whether you are seeking to understand the deep historical context of these legal clashes, studying comparative family law, or simply trying to comprehend the sheer, overwhelming complexity of living a faith-based life under a secular constitution, this detailed breakdown will provide you with unparalleled, actionable clarity. We are stripping away the confusion, the community rumors, and the rampant legal misinformation to show you the hard facts, the documented case studies, and the undeniable legal realities of navigating an Islamic divorce in the United States. To truly grasp the magnitude of this clash, we must first dissect the foundational mechanisms of Islamic marriage dissolution and observe exactly how they shatter when subjected to the rigid procedures of the United States civil court system in the year 2026. The primary and most frequently discussed abstract concept is talaq. In classical Islamic jurisprudence, talaq is the unilateral right of the husband to dissolve the marriage. It is often executed through a verbal or written declaration. Historically, this did not require the intervention of a complex judicial bureaucracy. It was a private theological execution of rights. But imagine if we transplant this ancient legal concept into modern-day America. Imagine a man named Michael, who converted to Islam, and his wife Sarah living in Chicago, Illinois. Let us say Michael decides the marriage is irreparably broken and pronounces talaq to Sarah in their living room. In his mind, and perhaps in the eyes of his local religious congregation, the marriage is now fundamentally over. He moves into a separate apartment, completely separates his finances, and believes he only owes Sarah financial support for the duration of her iddah, which is the religiously mandated waiting period of approximately 3 months. Michael is operating under a severe legal misconception that historical trends show ruins thousands of individuals financially. Illinois, like every other state in the country, operates under a secular civil framework that does not recognize unilateral religious declarations of divorce. To the state government, Michael and Sarah are 100% legally married. The potential outcomes of Michael's assumption are disastrous. Any debt Michael accrues after moving out, whether it is a new car loan or credit card debt to furnish his new apartment, is still legally considered marital debt. Furthermore, if Michael attempts to travel overseas and enter into a new religious marriage, he is walking directly into potential legal jeopardy, as the United States still recognizes Sarah as his sole legal spouse. When Sarah eventually files for a civil no-fault divorce 6 months later, the judge will not look at the date Michael verbally pronounced talaq. The judge will look at the formal date of civil filing, or the legally documented date of separation. The complete misalignment between the 3-month religious iddah and the state-mandated separation periods creates a volatile gap where financial liabilities accumulate rapidly, entirely unprotected by the religious framework Michael thought he was utilizing. This friction becomes even more complex when we examine the concept of khula. Khula is the religious mechanism through which a wife initiates the divorce. However, unlike a civil no-fault divorce where a woman can simply file paperwork and force the dissolution of the marriage regardless of her husband's objections, a traditional khula requires the husband's explicit consent. Furthermore, it typically requires the wife to offer financial compensation to the husband, most commonly by returning her mahr, the Islamic dower she received at the time of marriage. Let us look at a case study involving a woman seeking a khula in Texas in 2026. She goes to her local religious leadership, an informal Sharia council, and states her desire to end the marriage. The council contacts her husband, but he absolutely refuses to grant the religious divorce unless she agrees to surrender her secular legal rights to his 401k retirement account and the equity in their shared home. This scenario exposes a massive vulnerability in the dual system framework. The wife is now facing what family law attorneys call a limping marriage. She can easily walk into a Texas civil court and obtain a legal, secular divorce because Texas is a no-fault state. The civil judge will equitably divide the 401k and the home equity according to state law, completely ignoring the husband's religious demands. But religiously, because the husband refused the khula, she remains spiritually bound to him. If she wants that religious closure to remarry within her faith community, she is faced with an excruciating choice. She must decide whether to submit to what essentially amounts to religious extortion, signing away hundreds of thousands of dollars in secular marital assets just to secure a piece of paper from a religious council that holds no civil authority. When these specific scenarios reach the appellate courts, the potential outcomes vary wildly, but a distinct historical trend has emerged over the last decade. United States judges are increasingly scrutinizing agreements made under the pressure of a withheld religious divorce. If a woman signs a legally binding civil settlement agreement giving up her right to spousal support solely because her husband threatened to withhold the religious khula, secular courts can, and frequently do, invalidate that entire settlement under the doctrine of duress or unconscionability. The courts recognize that leveraging a deeply held religious belief to extract incredibly disproportionate financial concessions in a civil proceeding violates public policy. However, proving secular duress based on religious pressure requires immense evidentiary documentation, expert witness testimonies on Islamic law, and a highly specialized legal strategy that goes far beyond standard family law practices. Then we must address the ultimate religious intervention, fash. This is a formal judicial annulment of the marriage by an Islamic judge or religious body, typically granted when the husband is abusive, fails to provide financial support, or is incarcerated, and refuses to grant a talaq or accept a khula. In a completely Islamic legal jurisdiction overseas, a judge has the power of the state to execute a fash and enforce it. But in the United States in 2026, these religious councils are classified strictly as voluntary arbitration boards. They have absolutely zero police power, zero subpoena power, and zero ability to alter civil public records. A fash granted by a tribunal in New York is a completely symbolic gesture to the state of New York. This creates a terrifying legal vacuum. Many Muslim Americans mistakenly believe that an American civil judge's final decree of divorce automatically qualifies as a fash. They assume that because a judge with authority dissolved the marriage, the religious requirements are inherently satisfied. This assumption is fiercely debated among Islamic scholars in the United States today. Some theological circles argue that a secular judge applying non-Islamic law cannot legally execute a fash, meaning the couple remains religiously married despite the state decree. Other councils take a more pragmatic approach, recognizing the civil decree as a valid religious dissolution out of necessity to prevent communal chaos. This lack of centralized theological consensus leaves thousands of families playing jurisdictional roulette, completely unsure if their civil freedom translates to religious liberty. Every single step of this process highlights a fundamental truth. You cannot enforce religious theological concepts in a secular court, but those religious concepts will absolutely dictate the aggressive strategies used by opposing counsel. And the absolute epicenter of this battlefield, the one document that causes more financial devastation, drawn-out litigation and constitutional crises in American family courts than any other, is the Islamic marriage contract itself. Families sign this document assuming it represents a pure, unbreakable financial guarantee, completely unaware that secular judges are systematically tearing these contracts to shreds based on a single, catastrophic legal categorization. That categorization is the rigid, unforgiving legal classification of a prenuptial agreement. To understand why this is so devastating, we must deeply analyze the specific nature of the Islamic marriage contract, primarily focusing on the mahr, or the Islamic dower. In traditional Islamic jurisprudence, the mahr is a mandatory gift given by the groom directly to the bride. It is entirely her property. Structurally, it is almost always divided into two distinct parts. There is the prompt mahr, which is paid immediately at the time of the marriage ceremony, often a nominal amount, a piece of jewelry, or a specific sum of cash. Then there is the deferred mahr. This is a significantly larger sum, sometimes tens or hundreds of thousands of dollars, which is specifically designated to be paid out upon the dissolution of the marriage by death or divorce. Imagine if a couple, let us call them David and Amina, are sitting in a mosque in Virginia in the year 2026. They are surrounded by family, community leaders, and an imam. They sign a single-page document, often printed in both Arabic and English, detailing a deferred mahr of $75,000. In Amina's mind, and in the collective understanding of her family, this document is her absolute financial safety net. It is a religiously mandated guarantee that if David ever initiates a divorce, she will have the capital to restart her life. They sign the document, the witnesses sign it, and they enter into their marriage. 5 years later, the marriage breaks down. Amina files for a civil divorce in a Virginia family court. Her attorney presents the signed Islamic marriage contract to the secular judge, fully expecting the court to order David to pay the $75,000. This is exactly where the catastrophic legal failure occurs. The United States civil court system looks at this religious document and strips away all theological context. The judge sees a written agreement, signed before marriage, that explicitly dictates a specific financial payout contingent upon the event of a divorce. In the eyes of American civil law, this document is instantly and exclusively categorized as a prenuptial agreement. The moment the mahr is classified as a prenuptial agreement, it is subjected to the incredibly stringent, uncompromising statutory requirements of state family law. Historical trends and documented case studies across the country show a massive systemic failure of these religious contracts to survive this specific legal scrutiny. For a prenuptial agreement to be legally valid and enforceable in a United States court, it must pass a series of rigorous secular tests. Did both David and Amina have independent, licensed legal counsel review the document before they signed it at the mosque? Almost certainly not. Did David provide a full, transparent, and documented disclosure of all his financial assets, debts, and income streams to Amina prior to the signing? In traditional religious settings, this level of forensic financial disclosure practically never happens. Does the one-page religious contract explicitly state, using standard legal terminology, that Amina is knowingly and willingly waiving her statutory rights to secular spousal support or the equitable division of marital property? Absolutely not. Because the religious contract completely fails to meet these strict civil prerequisites, the judge has no choice but to rule it legally void, procedurally defective, and entirely unenforceable. The $75,000 safety net that Amina spent 5 years relying on evaporates in an instant. The court dismisses the religious document and proceeds to divide their assets strictly according to state law, leaving Amina in a state of shock and severe financial vulnerability. This is not an isolated loophole. It is a fundamental structural incompatibility between how religious communities draft their documents and how the state evaluates them. However, some highly specialized family law attorneys attempt a radically different strategy. Instead of allowing the court to classify the mahr as a prenuptial agreement, they aggressively argue that it should be viewed simply as a standard, secular civil contract. This introduces the legal doctrine of neutral principles of law. This doctrine allows a secular court to resolve disputes involving religious institutions or documents by applying objective, secular legal rules without ever interpreting religious doctrine. Under standard contract law, a valid contract simply requires an offer, an acceptance and consideration, meaning a bargain for exchange of value. Let us look at another scenario. Imagine a case in a community property state like California. A husband promises a deferred mahr of $50,000. The wife's attorney argues this is a simple contract. The husband offered the money, the wife accepted, and the consideration was her entering into the marriage. If the judge accepts this argument, they can enforce the contract purely as a civil debt. But this strategy is a massive gamble fraught with highly volatile potential outcomes. If the religious contract contains even a single sentence that ties the financial payout to specific religious behavior, the entire case collapses. For example, if the document states the mahr is payable provided the wife remains obedient according to Islamic principles, the secular judge must instantly halt the proceedings. An American civil court cannot constitutionally define, measure, or rule on what constitutes religious obedience. Doing so would be a direct violation of the First Amendment's Establishment Clause. The court will deem the contract inextricably entangled with religion and refuse to enforce it, once again leaving the dependent spouse with nothing. Furthermore, even if the secular court miraculously enforces the mahr as a simple contract, it creates a massive distortion in the overall civil divorce settlement. The civil justice system abhors double-dipping. If a judge in an equitable distribution state like New York actually orders a husband to pay a $100,000 deferred mahr, that judge will almost certainly reduce the wife's share of the secular marital assets to compensate. She might win the religious payout but simultaneously lose her legal right to half of his retirement accounts or the equity in the marital home. The religious victory directly cannibalizes her secular civil rights. Muslim Americans are walking into these courtrooms completely blindfolded, bringing ancient theological documents to a modern legal knife fight. They are relying on community tradition, while entirely ignoring the brutal realities of civil procedure. To survive this highly litigious environment, to ensure that a faith-based financial agreement is actually respected and enforced by a United States judge, requires abandoning the traditional approach entirely. There is a precise, legally bulletproof methodology to construct an Islamic marriage contract that bypasses the prenuptial trap and easily survives constitutional scrutiny, but it requires utilizing a specific legal instrument that most religious leaders fundamentally misunderstand and rarely ever recommend. That specific legal instrument is a formally drafted, heavily structured, state-compliant secular prenuptial agreement that systematically translates abstract religious obligations into strictly secular financial terms. To understand how this completely bypasses the constitutional and procedural roadblocks we discussed, we must look at exactly how legal professionals construct this document to survive the intense scrutiny of a United States family court. The fatal flaw most couples make is assuming the religious document itself can act as a standalone civil contract. The solution is to legally decouple the religious ceremony from the financial obligation. The Islamic marriage certificate provided by the local mosque should remain a purely spiritual document, outlining the theological commitment. Simultaneously, the financial promises, specifically the deferred mahr, must be extracted, stripped of all religious terminology, and embedded into a comprehensive civil contract governed entirely by state law. Imagine a couple, Omar and Fatima, living in Miami, Florida in the year 2026. They are preparing for their Islamic wedding. Fatima requests a deferred mahr of $150,000 to secure her financial future in the event of a dissolution. Instead of simply writing this figure onto the religious certificate in front of their community leaders, they engage in a radically different process based on historical trends of successful civil enforcement. Fatima hires a licensed Florida family law attorney to represent her interests exclusively. Omar hires a completely separate, independent Florida family law attorney to represent his interests. This dual representation is the foundational pillar of secular enforceability. When a civil judge reviews an agreement, the very first question they ask is whether both parties had adequate, independent legal counsel. If Omar and Fatima were to use the same attorney, or if only one of them had representation while the other signed the document in the hallway of the mosque, Potential outcomes point overwhelmingly toward the contract being invalidated later under claims of procedural unconscionability or coercion. Once independent counsel is secured, the process moves into a phase that is entirely foreign to traditional religious marriage customs: exhaustive financial disclosure. In traditional Islamic settings, a groom rarely hands over his tax returns, brokerage statements, and cryptocurrency wallet addresses to the bride before signing the mahr. However, under secular United States law, full financial transparency is an absolute prerequisite for a valid prenuptial agreement. Omar must provide a granular, legally sworn inventory of every single asset he owns, every debt he carries, and his projected future income. If he attempts to hide an offshore bank account or fails to disclose a minor business interest, and this is discovered during a divorce proceeding 5 years later, the judge will likely throw out the entire prenuptial agreement due to fraudulent non-disclosure. If the agreement is thrown out, Fatima loses the contractual right to her $150,000 mahr entirely. With full disclosure complete, the attorneys must perform a delicate surgical procedure on the language of the contract itself. They must apply the doctrine of neutral principles of law. This means completely eradicating any words like talaq, khula, Islamic obedience, or Sharia compliance from the operative financial clauses. Why? Because the moment a civil judge reads a contract that conditions a financial payout on whether a spouse violated Islamic behavioral codes, the judge hits a constitutional brick wall. The First Amendment strictly forbids the secular court from interpreting religious doctrine. Therefore, Omar and Fatima's attorneys translate the religious intent into neutral civil language. The contract will not state that the money is owed upon a religiously valid talaq. Instead, it will explicitly state that a lump sum payment of $150,000 is legally payable by Omar to Fatima within 30 days of the formal filing of a civil petition for the dissolution of marriage by either party in a state court of competent jurisdiction. By attaching the financial trigger entirely to a secular civil action, the filing of a divorce petition, the attorneys completely bypass the First Amendment entanglement issue. The judge never has to ask a religious scholar for an interpretation. They simply check the civil court docket to see if a petition was filed. Furthermore, the document must explicitly address the terrifying double-dipping scenario we explored earlier. The secular prenuptial agreement must clearly outline exactly how this $150,000 lump sum interacts with Florida statutory law regarding equitable distribution and spousal support. Does this payment replace Fatima's right to seek civil alimony? Or is this payment completely separate, meaning she will receive the $150,000 and still retain her right to demand half of Omar's 401k retirement account? If the contract is completely silent on this interaction, which religious certificates always are, the resulting legal battle will be catastrophic, draining tens of thousands of dollars in attorney fees just to argue over the original intent. A bulletproof civil document leaves zero room for interpretation. But what about the thousands of couples who are already married? Those who signed a one-page religious document years ago and are just now realizing it offers absolutely zero civil protection? For these individuals, the legal remedy is a postnuptial agreement. However, case studies demonstrate that postnuptial agreements face a significantly higher burden of proof in the United States legal system. Before marriage, individuals operate at an arm's length, meaning the law assumes they are looking out for their own best interests. But the moment you are legally married, you enter into a fiduciary relationship with your spouse. You are legally obligated to act in the highest good faith toward one another. Therefore, a postnuptial agreement attempting to formalize a religious mahr years after the wedding requires an even higher level of financial transparency and legal scrutiny to ensure one spouse is not using their positional leverage to exploit the other. The courts will examine a postnuptial agreement with extreme skepticism, looking for any sign of duress or unfair advantage. Drafting a secular fortress around your religious financial obligations is an incredibly complex, highly technical undertaking that requires recognizing the absolute supremacy of civil law within the United States courtroom. You are essentially using the state's own rigid contractual frameworks to force it to respect your private theological agreements. But securing the financial assets is ultimately just one piece of the puzzle. You can successfully map your mahr to a valid civil prenuptial agreement, successfully avoiding the procedural traps of secular law, and still find yourself completely destroyed by the next phase of the process. Because when the financial contracts are settled, a dual-system clash enters the absolute most brutal, emotionally devastating arena of family law. Everything changes. The strategies that protect your bank account are entirely useless when the abstract concepts of Islamic divorce collide with the state's absolute, uncompromising authority over the custody of your children. The moment a child is involved, the entire legal playing field shifts drastically, and the state government introduces a legal doctrine that completely supersedes any religious contract, private agreement, or theological framework you may have established. This doctrine is known as parens patriae, a Latin term meaning parent of the nation. Under United States civil law, the state government acts as the ultimate, overarching guardian of every single minor child residing within its jurisdiction. While you and your spouse may have the constitutional right to enter into complex financial agreements like prenuptial contracts to divide your property, you possess absolutely zero legal authority to contract away the state oversight of your children. A civil judge will meticulously review your property agreements, but when it comes to child custody, the judge discards all private contracts and evaluates the situation entirely from scratch using a single, uncompromising metric known as the best interests of the child standard. To understand why this creates such profound devastation for Muslim American families, we must deeply examine the traditional Islamic concept of child custody, known as Hadanah. In Islamic jurisprudence, the framework for custody is highly structured, predictable, and heavily gendered, primarily based on the age and gender of the child. Historically, the mother is granted physical custody of young children because she is deemed naturally best suited for their early nurturing and care. However, this physical custody comes with a rigid timeline. Depending on the specific school of Islamic thought being followed, this period of maternal custody traditionally ends when a male child reaches the age of 7 and a female child reaches the age of 9 or puberty. At that specific chronological milestone, the physical custody inherently transfers to the father. Furthermore, throughout this entire timeline, regardless of where the child sleeps at night, the father retains the position of wali, the absolute legal and financial guardian. He is traditionally granted the unilateral right to make all major decisions regarding the child education, religious upbringing, and medical care, while simultaneously bearing the strict religious obligation to fully finance those decisions. Now imagine transplanting this deeply embedded cultural and religious expectation into a modern American family court. Consider a case study involving a couple, Tariq and Layla, residing in Columbus, Ohio in the year 2026. When Tariq and Layla originally drafted their Islamic marriage contract, they included a highly specific, mutually signed addendum. This written agreement explicitly stated that in the event of a divorce, Layla would retain physical custody of their son only until his 7th birthday, at which point full physical and legal custody would automatically revert to Tariq. Both parties signed this document in front of their local religious leaders, fully believing they had secured a binding, faith-based custody arrangement. Years later, the marriage dissolves when their son is 5 years old. Tariq initially allows Layla to have primary physical custody, patiently waiting for the child's 7th birthday to enforce the religious contract. 2 years pass. Tariq walks into the Ohio family court, presents the signed, notarized religious agreement, and demands the judge transfer custody to him based on the contract both parties willingly signed. The potential outcomes of this strategy are universally disastrous. The civil judge will not merely ignore the religious document, the judge will fundamentally invalidate it. In the United States, it is a matter of strict public policy that parents cannot preemptively dictate child custody contract. The court views children not as property to be divided by a prenuptial agreement, but as vulnerable citizens entitled to a real-time, highly customized evaluation of their current well-being. The Ohio judge will apply the secular best interests of the child standard. This involves a granular, highly invasive investigation into the current realities of the child life. The judge will analyze which parent has been the primary caretaker for the past 7 years. They will evaluate the child's secular stability, their performance in their current school district, their integration into their neighborhood, and their emotional attachment to each parent. The judge will look at Layla's home environment, her work schedule, and her capacity to provide a safe, nurturing space. Because Layla has been the primary physical caretaker of the child's entire life up to this point, historical trends overwhelmingly dictate that the civil court will maintain that status quo to avoid disrupting the child life. The fact that an Islamic contract mandates a custody transfer at age 7 is considered entirely legally irrelevant. This collision between traditional expectation and civil reality frequently leads to a highly toxic, devastatingly expensive legal tactic: the weaponization of religious adherence within a secular courtroom. When Tarek realizes the state will not enforce his religious contract, he might attempt to win custody by proving to the secular judge that Layla is an unfit mother. Often, in these specific dual system cases, a parent will attempt to use the other parent's lack of religious strictness as evidence of unfitness. Tarek might testify that Layla has stopped wearing traditional Islamic clothing, that she fails to feed the child a strictly halal diet, or that she no longer attends Friday prayers. He attempts to convince the American judge that Layla's moral compass is compromised. This strategy crashes violently into the First Amendment of the United States Constitution. The secular judge is constitutionally prohibited from deciding what constitutes a good Muslim or a bad Muslim. The civil court cannot penalize Layla for abandoning religious practices, just as it cannot reward Tarek for maintaining them. The judge translates every single religious accusation into a purely secular safety analysis. If Tarek argues that Layla takes the child to secular gatherings he deems un-Islamic, the judge will only ask one question. Are these gatherings physically or emotionally dangerous to a child according to state law? If the gatherings involve standard, legal community activities, the religious objection is entirely dismissed. The court refuses to become a theological referee. This tension reaches its absolute peak regarding legal custody, which is the legal right to make major life decisions for the child. In traditional Islamic law, as the wali, Tarek expects unilateral decision-making power. In the United States civil system, the overwhelming default is joint legal custody, meaning Tarek and Layla must agree on major decisions, particularly education and religion. If Tarek demands the child attend a private Islamic school to preserve their faith, and Layla insists on the local public school for secular socialization, they hit a total legal deadlock. When parents with joint legal custody cannot agree, they are forced back into the courtroom to litigate that specific issue. The secular judge, unable to favor religious education over secular education due to the Constitution, will typically defer to the parent who spends the most physical time with the child or the parent whose choice maintains the child's current baseline of stability. Tarek realizes that his traditional role as the unquestioned wali has been completely legally dissolved by the state. These custody battles are not just emotionally traumatic, they are financially ruinous. Parents often drain hundreds of thousands of dollars in legal fees arguing over religious nuances that the civil court is fundamentally barred from considering. But the structural collapse of traditional family roles in an American courtroom does not end with custody or decision-making power. It extends deeply into the very financial survival of the children involved. While families waste their resources fighting over who holds the title of religious guardian, they walk right into an incredibly dangerous, heavily enforced financial trap regarding child support. They falsely assume that the strict, traditional Islamic concept of child financial maintenance perfectly aligns with the brutal mathematics of state-mandated child support calculators, setting the stage for wage garnishments, seized passports, and potential incarceration. This financial trap is rooted in the deep misunderstanding of how the traditional Islamic concept of nafaka interacts with the relentless, automated machinery of secular family law. In classical Islamic jurisprudence, nafaka represents the absolute, unquestionable financial obligation of the father to provide for his children's basic needs, encompassing food, shelter, clothing, education, and medical care. It is a continuous religious duty that persists regardless of the marital status of the parents. Many Muslim American men enter the divorce process fully intending to fulfill this religious mandate. They often sit down with their soon-to-be ex-wives, frequently mediated by a local imam or a community elders' council, and negotiate a fixed, monthly cash payment. They shake hands, sign an informal piece of paper, and fundamentally believe that this private, faith-based agreement completely resolves their child support obligations. This is a catastrophic miscalculation of American jurisprudence that historical trends show leads directly to severe legal jeopardy. Let us examine a highly common scenario currently unfolding in courtrooms across the country. Imagine a father named Hassan and a mother named Yasmin living in New Jersey in the year 2026. During their religious separation, they mutually agree that Hassan will pay $1,000 a month directly to Yasmin in cash to support their two children. Yasmin signs a document at the local Islamic center, explicitly stating she accepts this specific amount and forever waives her right to seek any additional child support through the state government. Hassan pays the $1,000 meticulously every single month, keeping detailed receipts, feeling completely legally and spiritually secure in his compliance. 2 years later, Yasmin faces an unexpected, severe medical emergency, loses her primary source of income, and applies for state food assistance, also known as SNAP, to keep her family afloat. The moment Yasmin applies for state aid, a massive, unforgiving legal mechanism is automatically triggered. Under federal law, specifically Title 4D of the Social Security Act, the state government instantly steps in to recoup the public funds it is paying to Yasmin. The state prosecutor, acting on behalf of the government, files a civil lawsuit against Hassan for formal child support. Hassan walks into the New Jersey family court, presents the signed religious document, and confidently shows the judge his stack of meticulous cash withdrawal receipts, expecting the case to be dismissed. Instead, the civil judge looks at the religious document and immediately declares it legally void and entirely unenforceable. The core reason for this invalidation is a fundamental pillar of United States civil law. The legal right to child support belongs exclusively to the minor child, not to the mother. Therefore, Yasmin possesses absolutely zero legal authority to waive, reduce, negotiate away, or limit that right through any private, secular, or religious contract. The civil judge completely ignores the $1,000 religious agreement and opens the state-mandated child support calculator. This calculator is a rigid, mathematically uncompromising algorithm. In New Jersey, which utilizes the income shares model, the court combines the gross taxable incomes of both parents, determines the total statutory cost of raising 2 children in that specific geographic area, and then assigns Hassan a prorated share based exactly on his percentage of that combined income pool. The secular judge does not care about Hassan's religious obligations. Them does not factor in the zakat, or obligatory Islamic charity, that Hassan faithfully pays annually. The algorithm does not care if Hassan is financially supporting his elderly parents overseas, which is another deeply held, mandatory religious duty in Islam. The secular formula is entirely blind to theology. The state calculator crunches the raw data and determines Hassan should actually be paying $2,200 a month. Instantly, Hassan is legally ordered by a federal court to pay more than double his religiously negotiated rate, completely shattering his financial reality. But the situation becomes drastically more severe when individuals attempt to proactively manipulate this secular system using informal community networks. Case studies reveal a devastating pattern where fathers, overwhelmed by the high civil calculations or attempting to minimize their state exposure, intentionally quit high-paying corporate jobs to work off the books in cash-based businesses owned by community members. They operate under the deeply flawed assumption that if they show zero official taxable income to the Internal Revenue Service, the civil court cannot force them to pay secular child support, allowing them to revert solely to their informal religious agreements. This strategy brings them face to face with the terrifying legal doctrine of imputed income. If a civil judge in 2026 suspects that a parent is voluntarily underemployed, intentionally hiding assets, or manipulating their career to avoid their child support obligation, the judge will completely disregard the father's stated, on-paper income. Instead, the court will legally impute an income. This means the judge will legally pretend the father is making a specific, higher salary based on his past education, his historical work experience, his specialized skills, and the current prevailing wage in the local job market. Let us say Hassan has a master's degree in civil engineering, but claims under oath he is now only making minimum wage working at a local community grocery store. The civil judge will forcefully impute an engineering salary of $120,000 a year onto Hassan and calculate his mandatory child support based on that phantom money. Hassan is now legally ordered to pay a massive monthly sum based on money that does not actually exist in his bank account. When Hassan inevitably fails to pay this mathematically impossible civil order, the state does not simply send a polite reminder in the mail. Child support enforcement in the United States is one of the most aggressive, relentless debt collection machineries on the planet. Unpaid child support rapidly accumulates as arrears. These civil arrears are essentially unforgivable debt. They cannot be wiped out or discharged in a standard personal bankruptcy filing. As the arrears rapidly build, the state government automatically deploys a series of escalating, devastating enforcement mechanisms without ever needing to haul Hassan back into a courtroom for a hearing. First, his wages are unilaterally garnished. His employer is legally ordered by the state to extract the child support directly from his paycheck before he even sees a single dollar. Next, the state treasury intercepts his federal and state tax refunds. If the arrears reach a specific federal threshold, typically around $2,500, the United States Department of State is automatically notified. Hassan's United States passport is instantly flagged and revoked. He can no longer travel overseas for religious pilgrimage,